Good morning, everyone. Welcome to the First District Court of Appeals. We have 4 cases on the docket to be argued. I'm going to call each case, and if counsel could just identify yourselves and indicate your readiness to proceed. The first case is In Re MH and JHC.
Required counsel for grandmother.
Okay.
Leon Hewitt, counsel for appellant, Mary Hughes.
Okay, thank you. The second case is Callaway versus Cincinnati Institute of Plastic Surgery.
Kayla King, counsel for the estate of James Callaway.
Okay, thank you.
Michael Lyon, Your Honor, for the defendants, ready to go.
Excellent. The third case is Hopkins versus Goebel.
John Hopkins on behalf of the appellant.
Okay.
George Parker on behalf of Timothy Hopkins.
Okay, great, thank you. And then the final case to be argued today is State versus Stancorp.
Senior Duncan on behalf of the appellant, Your Honor.
Okay,
Sean Donovan on behalf of the state, Your Honor, ready to proceed.
all right, excellent. So the attorneys in the first case can come forward. I will keep your time. Each side has 15 minutes to argue, and green means go, yellow means you have a minute left, and red means you're out of time. And for this case, I just remind counsel to please refrain from identifying the names of the children during the argument. Okay. Mr. Hewitt? Would you like to reserve any time for rebuttal?
Yes, I would.
And how much?
3 minutes.
Excellent. You may proceed.
Okay. First of all, good morning to all the honored and esteemed panel. My name is H. Leon Hewitt, and this actually is my first appearance before an appeals court, so I do my very best.
Welcome.
Thank you. The main point I really want this panel to look to understand is what my client, Mary Hughes, what she's had to go through and what she has to endure. From my client's viewpoint, she believes that grandmother has been acting, or more or less started on the issue of custody of her daughter, JH, later MH, and she believes that a lot of this has started when mom made the decision to move to Texas. When she made that decision to move to Texas, that's when my client believes that grandmother pretty much launched a crusade against her in order to make sure that JH stays with her. The issue that mother also has, not only with grandmother or her mom going after JH, but also the fact she was also going after and for seeking custody with MH, who more or less had always been with mother for most of her life. Mother also believes that 241 Kids had investigated her, had no problem with mother. However, mother did have multiple problems with the GAL, who was court appointed, in which she believes that they could not get along and they could not.
So I understand the points that you're making. I understand
Yes.
mother's frustration here and what she perceives as kind of this attack by the grandmother. But like what we have is the record as decided by the trial court. So if you could maybe focus on like where you think the trial court got it wrong, because
Okay.
we are reviewing this.
Well, let's start with finding of unfitness. The trial court found mother unfit when they made a ruling that mom had abandoned JH and then later on MH. Mother believes that grandmother has actively interfered with contact between herself and her children, MH and JH, and the court down below made it almost impossible because they do not get along. And the court's ruling, even when it comes to the issue of parenting time and visitation, they basically left it up in the air and saying, we will let the parties decide when mom can come and visit JH or MH.
I mean, the juvenile court is not unaccustomed to finding parties that don't get along in terms of trying to schedule supervised visits. I mean, the court has means at its disposal if one side is not allowing visitation or contact to ensure that that party has that visitation or contact. So I guess my question is, what steps did mother take if she believed she was not being allowed to contact the children to get the court to ensure that she could do so?
Mother has, basically, mother even bought MH a phone. Mother has sent text messages to MH. She's even, if I understand, mother has sent text messages to JH too. And there has been either no response from the girls, or when she tried to call, she sent text messages followed up by phone calls. And mother believes she's being blocked. She is not getting contact with her children. And the way the current order as it stands now, there is no set visitation plan. What's really required is, because mother lives in Texas, there really should be a plan for mother, like whether it be the summer, whether it be winter vacations, something should be laid out. And as the ruling from the court below, there is no such schedule that has actually been laid out for mother while she is fighting to get time for her children. Okay? So that, I think, is a very big issue. But even going back to the issue of finding her unfit, or based upon abandonment, if mom is being blocked from finding her children, it's easy for grandmother to force on the issue of abandonment, because mother cannot have any contact with her children.
Was there evidence in the record that mother, like text messages or any sort of proof that mother attempted to text or attempted to call the children?
I'm going to be honest, I can't recall if that was in the court's transcripts and testimony in court, but I do know mother has definitely pointed out that she was not getting access to her children after the children more or less were picked up. Now, that is in the record. There's also something else in the record regarding the father of JH, to which more or less reinforced mother's contention that she cannot get through, because there is in the record where the father of JH, who is incarcerated, at one time had access to a JH, but sometime during the proceedings, he lost access from speaking to JH. Grandmother even filed motions to terminate phone contact with children, which thankfully was overruled by the court, but it kind of shows the mindset of grandmother when it comes to mother, in terms of what efforts are being made to make it much more difficult for Mary Hughes to see and visit her own children. One other thing too, as far as mother's time that was allotted to her, they basically are asking mom to come either on every other week, to fly from Texas to Cincinnati. She owns her own business, and you can imagine that is a huge burden on her. But again, that is the current parenting time schedule, and it cannot or does not work for mom under a schedule like that, due to the fact that she does live in Katy, Texas, and have to come to Cincinnati so frequently just to spend time with her kids. So I do hope the court do consider that aspect of what the court had decided below. And I think that's pretty much what I have, Your Honor.
Okay, great.
Okay.
We'll reserve the balance of your time for rebuttal.
Thank you.
Okay, thank you. All right, Mr. Sawyer?
May it please the court. Good morning, Your Honor. My name is Christopher Sawyer, and I'm appearing on behalf of petitioner appellee grandmother Yvonnya Hughes. We respectfully request this court to affirm the trial court's grant of custody of JH and MH to grandmother. The issue in this case, as grandmother sees it, is whether the trial court correctly found by a preponderance of the evidence that mother is unsuitable to parent JH and MH, And if so, whether the trial court also correctly found by a preponderance of the evidence that that is in the best interest of JH and MH that custody be awarded to grandmother. The answer to both of those questions is simply yes. As this court is very well aware, a court may not award custody of a child to a non-parent without first determining whether or not that parent is unsuitable. The four things that the trial court looks for in determining suitability are that the parent has abandoned the child, the parent has contractually relinquished custody of that child, the parent has a total inability to care for the child, or the parent is otherwise unsuitable to care for the child. As it pertains to abandonment, Ohio Revised Code Section 2151.011(c) states that a child is presumed abandoned if a parent fails to visit or maintain contact for more than 90 days.
Counsel, Mom is arguing that she did not abandon these children because her efforts to contact them and be involved in their lives were blocked by your client. Can you address that?
Your Honor, with all due respect to counsel that is here this morning, he was not present at trial. I was. There was no evidence presented by Mother showing that her phone has been blocked in any way, shape, or form. The only evidence that Mother submitted was her own self-serving statements showing or indicating as such.
And what about the motion to terminate phone contact?
That was done after trial, after Mother's oldest child had begun making threats towards not only my client, but also his two younger siblings. So in an effort to protect the children and in the best interest of the children, we felt it was best that Mother's phone contact be terminated, especially considering Mother's actions leading up to trial, which included completely disregarding the court orders, where the court ordered grandmother to return the children to Cincinnati. She refused to do so. She came back to Cincinnati with both of those children for another court hearing, left town, which necessitated both kids being added to the National Missing Persons Registry. Subsequently, J.H. was located in Elizabethtown, Kentucky, traveling by car.
Is there any provision in the visitation aspect of the order to account for the fact that she does live in another state and it's difficult to get back here?
Mother filed for supervised visits because of her actions, as I was just explaining, and was subsequently charged with felony interference with custody. Mother did not exercise those supervised visits at the Family Nurturing Center. She then asked for unsupervised visits, which we vehemently opposed because of Mother's actions in fleeing with the children. She did not exercise those visits at all. She didn't make any attempts. She didn't make the payment to the Family Nurturing Center. She did absolutely nothing to exercise her visits.
But there's still a provision that would allow her to visit, right?
To my understanding, Your Honor, there is not.
Okay.
And that would be up to the trial court's discretion at that time based upon everything that was testified at trial, the guardian's position, etc.
Okay.
Now, getting back to Mother's abandonment, Mother has not had any contact with JH or MH. With JH, her last contact was in September of 2020. With MH, that contact was on February 3rd, 2021. Despite Mother's being awarded supervised visits as well as supervised phone contacts, she's never exercised it. To this day, she still has not. She's gone now over 2 years without seeing or speaking to either child through her own volition. Additionally, the trial court also noted mental health concerns with Mother. The guardian ad litem in this matter filed a motion, which the court granted, ordering Mother to submit to a forensic mental health evaluation. The only thing that we received as far as an alleged mental health diagnosis was concerned occurred on the night before trial, where we received via email a picture of a one-page document showing inpatient treatment is not needed. We have no idea who performed this test, what tests were performed. There was no testimony from an alleged expert at trial. We have no idea. Now, grandmother in this matter did testify, along with Mother's sister, that Mother has been diagnosed with bipolar disorder. Are there any other issues there? We simply don't know.
But there were no medical records
Correct.
Substantiating that, correct?
There were no medical records. It was a one-page picture of a document.
Or substantiating either way?
Substantiating either way.
Okay.
Now, Mother's argument regarding the court not putting any weight on the JFS worker testimony fails because this court, as well as numerous appellate courts throughout the state of Ohio, have routinely held that the trial court is in the best position to judge credibility of witnesses. And this court most recently held in Wilfong v. Bush, 2023 Ohio 1256 on April 19th of this year, the exact same thing. Counsel is simply asking for you guys to overrule the judge's determination when the trial court was in the best position to view the witness's demeanor, observe their testimony, hear everything they had to say. Now, moving on to best interest, it is in the best interest of JH and MH that custody remain with grandmother. This court is very well aware of what those best interest factors are. And not to reiterate every single thing I put in my brief, but just as a few, with mother, she fails to hit a single best interest factor through her own actions and inactions. She refused to follow court orders to return the kids. She's refused to exercise her supervised visits. She's refused to exercise her supervised phone contact. She has done absolutely nothing. Whereas with grandmother, both children are flourishing in every aspect of their lives. They're in school, which mother admitted at trial. She refused to enroll the kids in school because she knew people were looking for her and didn't want people to take her children. With grandmother, the kids are involved in extracurricular activities. They're earning A's and B's. They're either in or completed therapy. They are excelling in every aspect.
And there was a strong preference by the children to remain
correct.
with the grandmother, correct?
That is correct, Your Honor. Both children testified repeatedly, and I'm not sure if testimony is the right word, but at an in-camera interview, both children repeatedly expressed, and JH through her guardian ad litem, repeatedly expressed their desire to remain with grandmother and their desire to remain together as sisters not living apart. Now, just to address one other matter that counsel put in his brief, which is the alleged bias of the guardian ad litem. That issue was never raised in the trial court below. Mother, through her prior attorneys, never filed a motion alleging that the GAL was biased, either before, during, or after the trial. There was never any testimony elicited at trial, even though mother had the opportunity to cross-examine the GAL, and that is simply not for this court to address at this time. This court has repeatedly held that this court will not address issues for the first time on appeal when they could have been addressed by the trial court below. The GAL was simply fulfilling her duties to her ward, and not liking the GAL's recommendation is not a grounds for bias. And the last thing that I would like to point out, Your Honors, is that this court does not have the complete record from the court below. As this court can see in its entries, there was oral argument that was heard before the presiding judge on mother's objections to the magistrate's decision. And it is...
Was there any evidence?
There was no
Was that
evidence, but there was argument, but no evidence presented at the objection period.
So how would that be helpful to us if
This
there's no
court-
evidence?
This court, as is required by Appellate Rules 9A and 10B, require the appellant to submit a complete and accurate transcript of the proceedings below to this court so that the court has a complete record to determine whether or not
But you
the
don't have to
trial-
submit transcripts of stuff that's not germane to the issue on appeal. You just have to get everything in related to the appeal. And if there's no evidence being taken at that hearing, I think what Judge Bach is asking is, why would that matter?
It would matter because this court now has to determine whether or not Judge Bloom committed reversible error in sustaining the
Well, but
magistrate's
we can review
decision.
her decision and make that determination.
And I understand that, Your Honor, but I'm simply saying the transcripts, this court does not have the full record of those transcripts for that hearing. And because of that, as has been repeatedly held by this court as well as other courts throughout the state, the court is to presume the validity of the proceedings below and affirm the trial court's decision. Your Honor, we are asking that this court affirm the trial court's grant of custody to grandmother because mother is unsuitable to parent either child, and it is in the best interest of JH and MH that custody remain with grandmother. Your Honor, for the reasons I have just discussed, we request the trial court's grant of custody to grandmother be affirmed. Thank you.
Thank you. Mr. Hewitt, you have 5 minutes left for rebuttal.
Thank you, Your Honor. If there's the things I really would like the court to hear or highlight again, they talked about unfitness and unsuitability. Mary Hughes is the mother of 4 kids, and up until this incident happened when grandmother started filing for custody. Mother was being a mother. She was taking care of all of them, and there has been no major issue.
Counsel, am
Yes.
I misremembering? I thought that J.H. lived with maternal grandmother pretty much since birth.
That is correct. I also would like to at least let the court know that Mother Mary Hughes pretty much lived like right around the corner at that time. So J.H. pretty much was going between grandmother's home and her mother's home. But it is true that that grandmother did take J.H. in basically a couple days after her birth. But they did live close, right around the corner from each other until Mom decided to move to Texas. And then everything went haywire at that point. And then on regarding that, a mom being unfit or abandoning the kids, there's also been no evidence or testimony. Actually, there has been testimony showing that Mom had never been a danger to any of her kids, because even her sister had testified to that effect, that she's never been violent toward her kids. She's always been around and always been there for them. So that was not, so as far as any kids being in danger, that there was no evidence of that. Mother definitely feels she was wrongfully found to be unfit, and so she definitely objects to that. And again, parenting time with her children is a big issue that is unresolved, and so therefore we are asking the court to consider Mother's request to, if not reverse the lower court's ruling as to JH or MH, but also consider the issue of parenting time, where Mother is not getting any time that she's entitled to under the Constitution to spend time with her children. And thank you for your time.
Thank you. Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision, and we hope you both have a great day. Okay, the next case is Callaway versus Cincinnati Institute of Plastic Surgery. Ms. King, whenever you're ready. How much time would you like for rebuttal?
3 minutes, please.
3 minutes. Very well.
Good morning, Your Honors, and may it please the court. My name is Kayla King on behalf of the estate of James Callaway. This is an informed consent case. The defendant, Dr. McKenna, told James Callaway it would be safe to have an elective plastic surgery just 3 weeks after his ankle surgery. Dr. McKenna did not tell James that he had a high risk of getting a pulmonary embolism or a clot in his lungs. James went forward, he did get that clot in his lungs, and he died of the clot when he was just 33 years old. At trial, the jury found that Dr. McKenna failed to obtain James's informed consent. That's interrogatory number 4. And the jury looked to the instructions to understand what an informed consent claim requires. There was an instruction titled Failure to Obtain Informed Consent, and that instruction correctly laid out the elements under Ohio law for an informed consent claim.
I guess what I don't understand about your argument is with respect to interrogatory number 4 is there is the finding by the jury on the failure to obtain informed consent, but number 5 goes to the causation element, and it seems like causation was a significant issue at this trial, so I didn't really understand your argument that, if the jury answered this in a certain way, that's dispositive, because there still needs to be a finding of causation.
Well, an informed consent claim does include a proximate cause element that operates differently than how it was described in interrogatory number 5. So under a correct statement of the law, proximate cause requires that the undisclosed risk actually occurs and then proximately causes the harm. But interrogatory number 5 said that Dr. McKenna's conduct had to proximately cause the harm. And I do think that difference is meaningful based on the trial testimony and the way the jury answered the interrogatories. I think what the jury found is that James Calloway developed a DVT, or a clot in his legs, between the two surgeries. So it wasn't willing to attribute the harm to Dr. McKenna in that direct kind of way that's outlined incorrectly in interrogatory number 5.
Counsel, what do we do with the fact that not only was there not an objection to interrogatory number 5, but there also appears to be acquiescence?
I don't think we have to do anything with that other than review under plain error, which is what we're asking for. The estate didn't do anything affirmative. It didn't request the conclusions instruction or interrogatory number 5. It didn't help draft that language. And the Ohio Supreme Court has been clear in just recently in State v. McAlpin, that's 2022, Ohio 1567, that mere acquiescence doesn't take us outside of plain error review. I'd like to also touch on the exceptional circumstances of this case that merit plain error reversal. Here, the visiting judge admitted on the record that he didn't understand the nature of the informed consent claim, even though he took it upon himself to draft the conclusions instruction. That's transcript 1092 through 93 and 1097. The morning the conclusions instruction was read to the jury, the visiting judge told the lawyers that he was giving the jurors, quote, one wail of a convoluted sentence. That's 1102. He told the jury that the conclusion instruction is, quote, long, it's convoluted. I didn't know how to make it better than that. I struggled with it, and that's the best I could come up with.
Well, but I think part of I get that, and that's, the judge probably shouldn't be saying that to the jury, but by the same token, as we look at jury instructions in the cases that we see a lot of convoluted ones, some of which I think I would have a hard time understanding if I were a lay juror. So just the fact that it's convoluted or confusing doesn't mean it's error to provide that. And I think this gets to the question of whether there was any objection to this. The judge is saying, like, hey, this is convoluted. Why weren't the lawyers saying, well, maybe we need to make it clearer, Judge?
Yeah, I understand your point, Judge. I think, again, that's just why we're under plain error review, the absence of that objection. But the law is clearly wrong, and I don't think there's any dispute about that. There wasn't a dispute raised in the appellee's brief. The visiting judge, in his opinion below, didn't take issue with the fact that there's an error in the law. The way proximate cause is designed to work in an informed consent claim is different than the way it was described in the conclusions instruction and in interrogatory 5. If there weren't a difference, then we would just be talking about a medical malpractice claim. But informed consent requires a different burden of proof and a different proximate cause element. And that was correctly captured initially in the failure to obtain informed consent instruction, but then it was incorrectly described again in the conclusions instruction. And that's the point that derailed the jury. You know, back to what I was saying earlier about exceptional circumstances. I mean, yes, the judges said all these things to the jury, but also the jury indicated that they were confused by this exact instruction. And when the jury indicated its confusion, first of all, the judge took responsibility. He said, there's no question, it's my work they don't understand, I take responsibility. But then he also just directed them back to the interrogatories, which referred back to the conclusion instruction and repeated the causation mistake.
Can you address the comparative negligence problem that was identified in your opening brief? I didn't see much about that in the remainder of the briefing. Is that issue preserved?
The comparative negligence doesn't come into play in an informed consent claim. So it was also error for the conclusion instruction to fold that into the informed consent claim. But I think the way that the jury answered the interrogatories about attributing fault to James Calloway, they ascribed 0% fault to him in the end, so I don't think that that's determinative.
And was that issue preserved? Was there an objection to the comparative negligence piece?
There was not.
Counsel, it was my understanding that there was a length of time between the cosmetic surgery and your client's, or the decedent's death, correct? How
Yes.
long exactly was that?
It was about 3 weeks.
So,
No, I'm sorry, that's a misstatement. It was less time than that.
Okay. Okay, so considering that there was that time gap, would it be reasonable for the jury to determine that the surgery or the lack of informed consent wasn't the cause?
So I think the jury did conclude that there was the development of a clot in his legs after the ankle surgery and before the liposuction surgery. But the trial evidence was uncontroverted that if James Calloway had stayed on aspirin, that clot in his legs that formed would not have turned into a clot in his lungs, and that the clot in his lungs is what killed him.
Okay, thank you.
The last thing I just would like to say is that recently in State v. Bailey, the Ohio Supreme Court articulated what the prejudice prong is required under the plain error review. And they said that it's just that there's a reasonable probability that the outcome at trial would have been different. And I think that based on the evidence in the record, the way the jury was confused by the proximate cause requirement under an informed consent claim, and how those things interact, I think that there's more than a reasonable probability that the outcome at the trial would have been different. Had interrogatory 5 not been submitted, the conclusions instruction not been submitted, the jury would have returned a verdict in favor of the state on the informed consent claim.
Counsel, in civil cases, the plain error standard is even more exacting than in criminal cases, and we're instructed to apply this doctrine in exceedingly rare circumstances. Why is this that exceedingly rare case?
I think given all that was said in front of the jury, the way that this instruction came to be, the confusion the juries expressed, altogether, I think that these circumstances do undermine confidence in the underlying judicial proceedings. I think that the way that this all played out casts some doubt on the legitimacy of the decision, and I think that that's why plain error exists, is to protect that legitimacy and to correct the outcome when it's necessary.
All right, thank you, counsel. We'll reserve the balance of your time. Mr. Lyon?
I missed my flight yesterday, and I got in at 2 a.m., so I'm working a little. I'm pleased to be here once again. This is a unique panel. I'm not here to patronize you. The fact is we have 3 trial lawyers here on this panel, which we normally don't have. And that's important here because 3 of you understand, you lived with the importance and the integrity of the charge conference and how important it was, and the integrity and the importance of the collaboration by and among counsel and the judge in every trial to make sure that the case is tried fairly. That's what happened here. This case pended for 3 years. I was part of this trial. Preparing the trial, I tried the case. I know the case. Plaintiff's counsel and myself and the judge worked diligently from the very beginning to make sure that the jury instructions, the law, and the interrogatories were appropriate reflection of the law. We agreed to.
So where did this conclusion thing come from? Like that didn't seem to be something that either side proposed, and the judge just seemed to.
No, Judge Pater, Your Honor, and I'll be honest with you, I'm going to advocate for him here. I think this, frankly, I'm mystified about this appeal, and I'm mystified about these assignments of error. And why is that? Because Judge Pater had not had, I think, many experiences with medical malpractice cases, and they can be a little different. So he struggled a little bit with the concepts. But here's the point of this case. This is why it's so frustrating. He reached out to counsel, experienced counsel. Mr. Cooper is an experienced plaintiff's lawyer from Columbus. He's been for 30 years. I've been doing this for 49 years. I've probably tried 250 malpractice jury trials. I've been up here 80 times, for good or for bad. But the fact is, Judge Pater reached out to us, as a judge does, for assistance on drafting what would be a reasonable, fair jury instruction. He was struggling with that instruction. For some reason, he was having a hard time with the concept of informed consent. But as the court well knows, the jury instruction from OJI is the jury instruction that was given, and I'll get to that in a moment. But he came up with what he felt, this conclusory. He set forth this, he felt it was appropriate to give. We talked about it. Mr. Cooper talked about it. I talked about it. We agreed it was a fair statement of the law. I think in the transcript, Mr. Cooper says, you know, it's right on. He agrees totally with it. I don't know what we're supposed to do here. Not one time from the beginning of the submission of jury instructions and interrogatories throughout the trial to the time the jury came back, they had a question. They said they were a little confused. We collaborated. We agreed, myself, counsel, and the judge agreed that we would send them back with the judge's note saying, follow the jury instructions. There was no objection at that point in time. There was nothing at that point by plaintiff's counsel saying, you know, these instructions are inappropriate. We collaborated, as we always do. We went back. The jury found what they found. So we were working with the judge at no step of the way, Your Honor. Did plaintiff's counsel ever issue one scintilla of objection to any of this? This is what's so frustrating for me. I don't know how they get past the Goldfuss-Davidson case. When the Supreme Court of Ohio says, quote, and Judge Kinsley is absolutely correct, they're talking about a criminal standard. This is the civil standard. In appeals of civil cases, the plain error doctrine is not favored. Be applied only in extremely rare cases involving exceptional circumstances where error, to which no objection was made at the trial court, seriously affects the basic fairness, integrity, or public reputation of the judicial process, thereby challenging the legitimacy of the underlying judicial process itself. And that's what's at issue here. The integrity of the process we went through collaboratively as officers of the court and Judge Pater himself throughout this. I don't see how they get past this, but if they get past this, if this court allows them to get through that door to even be up here arguing when there was no objections whatsoever, okay, then let's talk about what happened. In court, during the trial, plaintiff's counsel spent 20 minutes on interrogatory number 5, which was the causation. There was no objection. There was no attempt to fashion an interrogatory 4 that says, if you find for informed consent, yes, for the plaintiff, then go to the general verdict form for the plaintiff. That's what they're trying to argue here. When Ohio jury instruction says, as one of the components of informed consent, quote, the risks and dangers that should have been disclosed by the defendant actually occurred and were a proximate cause of harm to James Calloway. Causation is an element of the tort of informed consent. Now, the counsel talks about informed consent being like some kind of strange, different tort separate from medical malpractice. It's a component of medical malpractice. It's a cause of action in medical malpractice, but you have negligence, you can have informed consent. But it's not anything different. You still have to have causation. And the jury determined there was no causation here, and there were many reasons why they could have determined that. Now, what's really fascinating about this case is this. Counsel seems to think that the comparative negligence component of this has no bearing. This is the only case I've had of informed consent where I think the evidence demonstrates unequivocally beyond reasonable doubt that Mr. Calloway didn't care. Now, why do I say that? Informed consent is the concept where a physician is going to tell a patient the potential risks based on data and empirical studies. Here are the potential risks of a DVT, a blood clot, whatever. In this case, what do we have? We have Mr. Calloway in real time being told by two separate physicians, you have a pulmonary embolus. You need to go to the doctor.
This
You
is
have a
after the surgery.
Pardon?
This is after the surgery.
This is after the surgery. This is important, and this idea that there's no evidence that demonstrates that if Mr. Calloway had been told A, B, C, or D, he would have done something different. My point is this, is that it's just the opposite. In this case, he was told in real time by doctor number one, you have a pulmonary embolus, you need to get to the hospital, you may die. He was told that, he didn't go. 5 days later, he goes back to his primary care doctor. She hears this history. He tells her, 5 days ago, my doctor told me to go to the doctor. He thinks I had a pulmonary embolus. She says, I think you have one too. I'm going to get an ambulance. He doesn't. What does that tell you about Mr. Calloway? Do we really think Mr. Calloway would have reacted to some type of potential risk? No. So I think the jury had this information. Juries are smart, they're sophisticated, they know what's going on. And in this case, they found there was no causal relationship between the fact that McKinney did or did not do what he was supposed to do as far as informed consent and the causation. There was all kinds of expert testimony that aspirin wouldn't have made a difference, that he very well could have had this pulmonary embolus. He probably had a DVT before the first operation, et cetera, et cetera. And Mr. Calloway's own conduct. Dr. Megorian, my expert, testified that had he gone to the hospital when he was told, it's highly probable they would have intervened, treated him successfully, would have lived. So the jury had many different pathways to go on causation. They decided to go the way they did. For the life of me, I don't understand what they're asking you to do. What would be the law of the case? Are they asking you to render an opinion that says once there's a finding on informed consent, there's no need for causation? That's not the law in Ohio. That's not Nickel versus Gonzalez, and there's case after case after case. What are they asking you to do? I don't know, but I'm very frustrated. You can see that. Because Judge Pater, God bless him, he worked very hard to get it right. And this record, if you haven't read it already, I know you will, you'll see over and over and over, counsel not only acquiesced, counsel participated in giving the imprimatur to these jury instructions and to the interrogatories. Now, the idea that the conclusory instruction was in some way inappropriate or not accurate, page 26 of our brief spells out, when viewed in their entirety, and this is what we have to, and you know this, when viewed in their entirety, the charge and interrogatories must constitute a fair, proper charge. Well, that's exactly what we have here. Maybe his conclusory instruction was a little misleading or a little difficult to understand, but when we told the jury to go back and read the jury instructions, the OJI, this encompasses the law in Ohio. There was no objection to that. So the combination of the OJI instruction along with the judge's conclusory and the interrogatories clearly manifests a fair representation of the law that the jury had in front of them. So then we get to the trial. In their brief, they're talking about how Judge Pater rushed them at the very end. That's just inappropriate. It's inappropriate. Judge Kinsley, you lived in the Sixth Circuit. You know the federal. I think there's some federal judges that would almost sanction them for this argument here. How disingenuous this is to argue that they don't need causation in this case. At the very end, the judge invites us up, as they always do, to look at the interrogatories. Counsel did, I did. They looked at them carefully. Is it any issue? No. Do you want to poll the jury? They didn't even poll the jury. If there was an issue with those interrogatories, there's the time right then and there to say to the judge, look, Judge, they signed interrogatory number 4, yes. That means...
Right, if there's an inconsistency like that needed to be brought up at that time.
Right then. You have the jury there, send them back. If that's what the law was, say, Judge, we think, at least make a record and say, we think you should send them back and enter a verdict for the plaintiff. They didn't do that. And frankly, and you saw Judge Paters, if you haven't seen it, you've seen his decision. He didn't even have a hearing. He didn't even ask for us to respond when he wrote his opinion. He was so outraged, and understandably so. So I think as officers of the court in collaborating in trials, this is a manifestation of a case where the result was not what they liked, and somehow, some way, they're trying to create a new law, I guess, as it applies to medical malpractice that just doesn't exist and shouldn't exist. So I ask you to affirm the jury's and the integrity of the jury's decision in this case. Thank you so much.
Thank you. All right, Ms. King, you have 5 minutes.
Can you repeat that, Judge?
5 minutes.
5 minutes? I'd like to start just by responding to a couple points that Mr. Lyon raised. First, there's a lot made about the fact that there wasn't an objection below. We acknowledge that. Goldfuss stands for the proposition that a plain error is the correct standard of review when there hasn't been an objection in the court below. And most recently, State v. Bailey articulates how plain error operates. And in that case, the Supreme Court said that there has to be clear error, that the error is obvious, and that there would be a reasonable chance.
Ms. King, that's a criminal case, though, correct?
It is, but I don't think the standard is different or the test is different in criminal as opposed to civil cases. Both require exceptional circumstances. I think there's some indication that the court's a little bit more hesitant to apply plain error in the civil context, but I don't think the test is actually different.
Counsel, your opponent is arguing that, and I'm going to summarize here, that even if the instructions were changed to what you're asking for, there was plenty of evidence in the record to justify the jury's verdict anyway, to show that the causation element just wasn't met here. Can you respond to that?
Yeah, I think that is a misunderstanding, again, of the causation error that we're taking issue with. So if you're looking at the incorrect statement of the law, that what was required for causation was that Dr. McKenna's conduct somehow had to directly contribute to the pulmonary embolism, then I agree. And I think that's where the jury got confused and was misled. But the correct way that proximate cause operates in an informed consent claim is that the undisclosed material risk just has to actually occur and then proximately cause the harm. And there was uncontroverted evidence that that's what happened here, that James wasn't told he was at a high risk of developing.
So what you're saying, just to make sure I understand, is even if there were intervening causes, intervening decisions by your client, not to go to the hospital and stuff, that's irrelevant as you're articulating the causation standard in informed consent.
I think that there can be more than one proximate cause of harm, but yeah, I think the way that the informed consent claim works is that as long as there is a proximate cause connected to the undisclosed risk materializing, that the elements of that claim are met.
So it would be irrelevant in your perspective that Mr. Calloway ignored the warnings, didn't make the appointments, et cetera, the evidence that Mr. Lyon pointed to?
I think that in this case it is irrelevant because the jury ascribed 0% of the fault to those actions when it answered the interrogatories. So I don't think that undoes anything about the way proximate cause operated here, which is that, had James known that he was at this heightened risk, he would not have gone forward. And that's something else that Mr. Lyon said that I wanted to respond to. There was clear evidence at the trial from James's wife that he would have never gone forward with the liposuction when he did, had he known about this heightened risk he was under. He had a young daughter, he had a successful business. He wasn't about to take a shot and hope that he didn't, that this heightened risk didn't materialize. He would have delayed the liposuction surgery. So we have the failure to disclose the risk. We have that James would not have gone forward with the surgery at that time had he known about the risk. And then we have uncontroverted evidence that had he not gone forward with the liposuction, he would have stayed on aspirin. And if he had stayed on aspirin, he wouldn't have gotten the pulmonary embolism that killed him. So that's the correct way that proximate cause operates in this claim. And that's what the jury found when it answered interrogatory number 4. It found that, causation isn't just this separate issue. It's baked into the claim, and it was baked into interrogatory number 4, and the jury answered that in the affirmative for the estate. Thank you.
All right, thank you. Thank you both for your arguments today. The case will be submitted. We'll get out a timely written opinion, and hope you all have a great day. Okay, the next case is Hopkins v. Goebel. Mr. Grossman? Would you like to reserve any time for rebuttal?
Yes, 7 minutes.
I'll let you reserve 5 minutes.
Okay. Because I think my brief has pretty much covered our argument. And in this case, we filed post-judgment motions for attorney's fees. And that, of course, extends the time for filing notices of appeal.
Well, so let me stop you there, because it does until there's a ruling, and then there's a ruling on the first motion, and there's no appeal.
That's right.
And then the time expires, and then you file the second motion. So do you agree that any appeal as it relates to the first motion is out of time?
No, I don't. And the reason for that is because they infected the first ruling with error by misrepresenting the facts to the court. And I immediately...
So, okay, I understand that that's your argument on the merits.
Right.
But my question is, you didn't appeal that within 30 days. Even if that's true, that it infected whatever happened else, what is the justification for not filing an appeal within 30 days of that?
Well, because I filed 3 or 4 different motions for fees. They were not ruled on in the first ruling on August 11th. And I filed a motion for fees under 3D2, and I put that in my brief that was submitted to the court on August 10th. I made that filing before the court ruled on August 11th. I also filed under Civil Rule 11, which is not clearly ruled on, and under the court's inherent power, which is not clearly ruled on. And the appellate rule clearly states that you have a suspension of the 30-day time to file until all post-judgment timely motions for fees are ruled upon.
But the court ruled against you.
The court only ruled against us on 2323.51, and that's the one, and I'm not merely saying that this was I'm believing that ruling itself is interlocutory because it was infected with error. And if that's not...
That's not the standard.
Okay,
and
well,
I mean, look, there's always error. I mean, that's what everyone is always alleging when they come up on appeal. You don't get to extend the time period to appeal just because there was error.
Well, then here's the conundrum the court has. Because I am directly stating that there was a lie, not merely a mistake, but a lie made during that first hearing. And that lie is what the court relied on in rejecting the motion for fees under 2323.51.
But that goes to the merits. That doesn't go to our jurisdictional power.
Okay, so I'm
And
trying to address that.
you've got, so then that's your second motion, that
I
like
agree,
there was there was a lie, there was whatever.
And I agree, and that would give you the right to address that aspect of it.
Right.
And I appreciate that. But the reason why I think it's important to understand the first motion is, from my standpoint, I don't want to have multiple appeals going on. I don't want to have multiple proceedings before this court. I want to do it all at one time, and because I think that there is a jurisdictional basis for this court to understand that when you infect a decision with a misstatement, and I raised it right away, that very night before, I sent an email to the court's clerk putting this forth and then telling the facts. And then the very next day before the court ruled, I set forth the error that was being made factually. And I then did everything I could to correct it. And you're right that perhaps we should have filed a notice of appeal, but I felt the real error now that was unmistakable was lying in that proceeding to fool the court into denying the first motion.
Counsel, can we go back to something that you said earlier? I thought I heard you saying that in your original motion, you sought fees on the basis of the frivolous conduct statute plus Rule 11 plus Rule 3,
Yes,
and the trial court only ruled on the frivolous conduct piece
I believe that that's correct.
and did not rule on Rule 11 and Rule 3?
She did not mention that in her ruling.
And so from your perspective, those pieces of your motion were still pending?
Outstanding. Yes, that was my position, and that's the position I offered to the court. And I then filed a separate motion under 3D2, even though I had raised it at the hearing on August 10th, even though I presented it in my memorandum that I gave to the court and the court accepted during that. I then filed separately that motion before she ruled on August 11th. And therefore, that was, I believe, a timely motion and preserved my right to appeal. And again, I'm, like in most interlocutory cases, I'm trying to get a final ruling on all the fee motions. And that's why I mentioned the App Rule 4, and I appreciate very much your comment, and I'm telling you what I did do. And this is the first time I've even had the experience, because you know this rule about attorney fees thing was not changed until, I don't know, 5, 6, 7 years ago. And so when I was reading the rule, I felt like this was the appropriate way to do it with the efficiency of the court, and that I was within the jurisdiction. But even if that wasn't the case, I still believe that I had a right to file the subsequent motions. I did. The court did rule on them on November 3rd. I made appropriate appeal in your jurisdiction with that. And from my standpoint, there's an abuse of discretion when a court knows that they've been lied to. And
Well, let me ask you about that,
Yes.
because I'm not aware, and if you're aware of something, please let me know,
Sure.
of any case where we have, where the trial court has been asked to impose sanctions, the trial court has declined to impose sanctions, and we have reversed and said, no, you must impose sanctions. And I feel like that's because we generally defer to the trial court on these questions about, were you misled? Did someone say something inappropriate to you as the judge? Like, that seems to be something that we normally defer to the trial judge on.
Okay, but take a look at the evidence. The evidence is clear that a lie was made. That is-
Counsel, can we talk about that?
Sure.
From my review of the record, it appears that they are saying that the service at the Indian Hill property related to the dismissal of the first action. And your proof that you submitted with the second motion relates to service of the second action, which happened at the Mason property. So it seems like maybe there's an apple and orange issue occurring. Can you speak to that?
Yeah, that's not what's going on. There were two different things happening. There was a motion to enforce, because the court retained, in the first case, was before Judge Peeler in 20 CV 93334. That case was settled and dismissed with prejudice with a retention of exclusive jurisdiction to enforce that agreement by Judge Peeler in Warren County. There was a motion filed to enforce the judgment for violating the agreement, and there was a new complaint filed, which is the 94450 case at the same time. So those two things happened, but the service of the motion for violating the agreement, was done by email. There was no personal service on that. It was done by email because it's the same case. Mr. Hopkins served as counsel in that case. The subsequent case, the new case, filed on August 2nd or 3rd of 2021, was first we attempted sheriff's service in Warren County. It was unsuccessful. We then tried certificate of certified mail service, unsuccessful in Warren County. Then we did resident service in Warren County, which was successful, but we also then hired a process server, which is what they've talked about. They were talking about the process server that was hired to serve the complaint, not the motion to enforce a violation of the settlement agreement in the 9334 case, but the new lawsuit. And that was actually served by Mr. Eccles, who was asked to do it at the home in Warren County, but they found out that he was going to be at a hearing in Mason Municipal Court, and that's where they served him. There was never any contact in Hamilton County whatsoever. That was a complete fabrication. And in fact, from page 5 on, their brief, everything they state is frivolous and could subject them to me filing a motion for 2323.51 in front of this court, which you can take cognizance of, because all of their factual statements are false. They're none supported in the record, and they're not true. And that's, so you're right. Typically you say, well, the court has an abuse of discretion on this. But when the lie is completely clear, there's no, they don't give any evidence to support the lie they made. And it's not an apple is an orange thing. It has nothing to do with that. It has the fact that they're lying about a process server that never was there in Indian Hill. And the idea that some sheriff deputies from Warren County that we had nothing to do with were somehow at his property in Indian Hill, we have no knowledge of that. We didn't send any sheriff deputies there. The only sheriff deputies were, am I up with my time? I don't know.
You got about 30 seconds if you want to
Okay.
reserve 5.
So the sheriff deputies were only in Warren County on the first lawsuit to try personal service on August 9th, 10th, and 11th of 2021. They never went, and they don't have jurisdiction in Hamilton County. They don't go there. And we didn't have anything to do with that. And that, by the way, never happened. So once again, there's an awful lot of factual dispute here, but my problem with what the trial court did was that there was never any consideration of the fact that this is a clear lie. And under the judicial canons, I believe the trial court itself had a duty to inform the disciplinary counsel that this lie had been made. And
Mr. Gressman,
so, I mean,
you're at your time if you want to
very
reserve
good. Thank
5. Mr. Parker?
May it please the court and counsel. On behalf of Mr. Hopkins, we ask you to affirm the trial court's denial of Mr. The Goebel's third motion for attorney's fees and costs. You need look no further than the November 3rd, 2022 decision of the trial court judge in the trial, the transcript of the docket, document number 48, where the court denied the third request without a hearing. The Pitcher versus Wallman case sets forth the 2 reasons Mr. Grossman failed to follow local rule in making the request, and then he didn't even ask for a hearing on that third request.
I'm sorry. I was thinking of the first motion and the second motion. Where's the third one?
He actually made the first request in May for sanctions under 232351. Then he makes a second request on, I believe, August the 11th under Rule 3. Then he makes another one, I think, on September the 10th under 232351 and Rule 11.
Okay.
So that's actually the third request. The last.
Counsel, could you address the final appealable order issue in that regard? What did the trial judge deny, and what would have been appealable at that point?
So, a difference of opinion doesn't make someone lying. Like, for example, just earlier today, you asked Mr. Grossman if his first motion included a request under Civil Rule 3D. He told you it did. I was looking at it. I don't think it did. So should he be sanctioned for the whole time we were here because he made a misstatement to you? I don't think so. But if we go back to that first motion in May, It was somewhat nebulous on whether or not it was under Rule 11, but it clearly was under 2351. And at that point, that was within the 30 days after the initial appealable order. So he elected his remedy. And with the election of the remedy to seek sanctions under 2351 on August the 11th, the trial court judge denied his request. And that is not an interlocutory order, that's a final appealable order. We don't think you have to look any further. We don't think the court committed error. To be brutally honest against ourselves on this, we suffered the worst sanction by the dismissal of the action. I mean, that's the worst sanction we could have had, because we believe that there was, while it wasn't the proper venue when you apply the jurisdictional priority rule, which we accepted, it should have been a transfer but not a dismissal. But guess what? She dismissed it. So that's, I think that in effect it's the same thing. So I wouldn't call Mr. Grossman a liar as much, just because we disagree on an issue, as much as I wouldn't want him to be declared to be a liar for looking at you earlier and telling you that his first motion for sanctions including something it didn't. But once he made that election of his remedy, that's the one we had. And then to keep filing things thereafter, after the court doesn't have jurisdiction, really, in all fairness, they should be sanctioned, and we're not even asking for that. Thank you.
Thank you. Mr. Grossman, you have 5 minutes.
Yes, so our first motion for fees that was filed at the end of May of 2022 was under Civil Rule 2323.51, under Civil Rule 11, and the inherent power of the court for bad faith conduct. Then, at the hearing on August 10th, we presented a memorandum, and in the oral argument, we said we felt that the court could also award the fees without finding a frivolous conduct under Civil Rule 3D2. And the point there is, under the civil rules, you have the right to award fees as a court if a action is filed in the wrong county, which this clearly was in the wrong county. But the rule says that you award fees, the court may award fees when you transfer the action up to the point of the transfer. Now, there was no transfer in this case. We didn't ask for one because, remember, on March 15th of 2021, they filed their same claims that they filed in Hamilton County in Warren County, the exact same claims, identical claims. So they had two different lawsuits, and then they refiled their malicious prosecution and abusive process claim in Hamilton County, same claims they filed in Warren County on March 15th. There was no transfer that we needed to ask for because, of course, they were already doing it. But that doesn't mean that I think the spirit of the rule would apply, which is you file in the wrong county, you can get an award of fees. And all I'm asking of the court is to inform the trial court that that's the case. And the court only clearly addresses all of our fee motions on November 3rd. Then it's clearly addressed. And remember, the only reference in the entry on August 10th is to 2323.51. There's no other reference to Rule 11. There's no reference to the inherent power of the court.
Well, but if the court is saying, I'm denying your request for sanctions,
yes, I agree with you.
Is it obligated to delineate all of the bases for sanctions in order to render it final?
I believe it is. And the court could have said in November 3rd, I already ruled on this, we're done. That's not what the court did. The court recognized that the court had not ruled on all these matters. And I've made it very clear at this point what those matters were to be ruled upon, when they were filed, how they were filed, and then the court legitimately then ruled on all of them. And I do not dispute that on November 3rd, the court is saying, I'm not going to give you any fees in this case. And that's why I believe after Rule 4, strikes that as the date for filing all questions about fees at that point, including the first one. And I appreciate your reluctance, and I'm guessing that the reason why this oral argument was set off at some date when you did it, when I filed the reply brief in April, is because the court was seriously wondering whether or not it had jurisdiction over this appeal. And I appreciate that. But this is a case where clearly there was jurisdiction over the subsequent motions, and I filed. All of the filings on August 10th were before the court entry came on, even though in the docket it indicates that there's somehow a difference. But my filings were all at the same time. And you'll see that some of them were before the court's entry was put on, but they were all put on beforehand. And so I filed to clarify the record. I filed the 3D2 motion for fees. I did all of that. And again, clearly the second motion for 23.51 and Civil Rule 11, it was timely and based upon the lying. And I appreciate the fact that the court doesn't necessarily have to hold a hearing, but when the lie is absolutely clear, when there is no question the lie was made, and the lying goes on in this brief.
Well, but see, this is what I have trouble with. You're saying it's absolutely clear. No one could ever disagree with that. And yet the trial court did. The trial court didn't see it that way.
But the trial court did not have the evidence of the lie on August 10th. The evidence.
But it had that evidence, whatever evidence you wanted was there when it ruled in November.
Right, and what's the response to that? Because remember, the court is ruling based upon a claim that we had a process server in Hamilton County running around the property, which doesn't create venue. But that was not true. And there was no evidence presented to the court that it was true, and the court didn't hold a hearing to determine that evidence, and we presented certified records from Warren County proving indisputably that this was a lie. So that's why I'm saying it's an abuse of discretion. The court doesn't have discretion to find facts for which there's no evidence. They admit in their brief, we're not presenting any evidence, and they didn't. No evidence was presented by them. And they state facts that aren't in evidence that are flat not true. And lawyers are not supposed to do that. And they did that in their appellate brief. They did that in front of the trial court, the trial court accepted representations of counsel as an officer of the court, and I agree.
Mr. Grossman, you're at your time now.
Thank you so much.
Yeah. Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision. Hope you both have a great day. All right, our final case today is State versus Stancorb. Mr. Duncan, Mr. Donovan, appreciate your patience. Mr. Duncan, whenever you're ready. Would you like to reserve any time for rebuttal?
I would, Your Honor. 5 minutes.
Very well.
May it please the court. Tanner Duncan representing the defendant and appellant in this case, Mr. Robert Stancorb. Your Honors, I believe that the majority of the arguments have already been submitted sufficiently. With the brief, I did want to take this time to identify particularly two cases that I believe are directly on point. What we have.
Before you get there, I want to focus you in on something. Since there was no challenge to the admissibility of the blood alcohol tests, correct? Or of the results?
Correct. That would have been properly done through a motion to suppress, and that is not an issue before the trial court or this appellate court in this case. Okay, so
because there was no motion to suppress, I'm kind of struggling how there's an argument that the court couldn't consider that test.
The argument in with the blood alcohol content is that a number alone is not sufficient.
Well, it wasn't alone. There was other testimony.
Well, specifically answering your question about the blood alcohol content, the test that was done, that would be relevant as a number in and of itself for purposes of the per se offense of which there was an acquittal. But since the conviction that is being appealed here is under the A1A section, that actual number in a vacuum without any sort of expert testimony to explain the nexus between an actual number and impairment That is why that number is not sufficient for the conviction under the A1A.
Wasn't there evidence of impairment that the state in its brief points to witnesses describing Mr. Stancorb driving kind of erratically and going over a median or something like that?
There was evidence of erratic driving. I mean, obviously, there was a significant, I think it was a severance of a femoral artery as a result of a single car accident. But in and of itself, that evidence of erratic driving, there is, similarly to a number, no nexus of impairment. I mean, there's erratic driving, there's poor decisions made on a motorcycle all the time, but erratic driving in and of itself is not sufficient for conviction of anything under 451119.
So we'd need a connection, something to connect the number to the behavior? Is that what you're
Absolutely,
saying?
and that connection would have to be expert testimony when it is a conviction under A1A. If it was a conviction under the per se offense, then that expert testimony is not required.
So the fact that the trial court found that there was definitely, I think she used definitely, alcohol in your client's system in combination with the erratic driving and going the wrong way on a one-way and going over the curb. So what else was needed? I mean, if the fact that there was alcohol and there was this erratic driving, why isn't that enough?
Evidence of impairment is what is required. It kind of harkens back to a similar voir dire line of questioning of if I were to consume an entire bottle of whiskey right now and have a blood alcohol content, there would not be a specific blood alcohol content at that time. It's getting to the idea of the separation of impairment with that number, the disconnect between those two ideas. A blood alcohol content of 183 does not necessarily mean that that person is under the influence, because that standard is noticeable and appreciable impairment. We cannot tell anything about impairment by looking at blood in a vial alone, or in this case here, not just the blood in the vial, but the lab report that was presented. Again, there has to be some nexus that is caused, that causes that
Counsel, why
connection.
can't we draw an inference, as we do in criminal cases all of the time, between the evidence of the conduct and the evidence of the blood alcohol level? Why can't we just make an inference there?
I don't think that is permissible by law. I think by law, in order to rely on a blood alcohol content in an A1A prosecution, there has to be some sort of evidentiary finding that the state was able to do. In fact, they did have a lab technician there. They did not designate that lab technician as an expert. They did not offer any sort of expert testimony, and the state was able to do so, arguably with the witness that they even brought in, and only had any sort of lay testimony given. But that actual number alone, again, in a vacuum, is not relevant to, or it does not actually get to the connection there of not the actual, the needed standard of being under the influence.
What
Under the
kind
influences.
of witness would testify to this? Would it be a medical expert, a police officer? I mean, who would be able to say what impairment looks like in a person?
Likely a medical expert that would say this is what a defendant with a blood alcohol content of this level would likely have signs of. This is what a person, any sort of testimony, opinion testimony of someone with this reading, a .183.
But do you need it that specific? What if there was the guy who was serving him drinks at the bar said, like, yeah, I served him, 4 drinks in quick succession, and he seemed to be slurring his speech and stumbling. Like, isn't that sufficient?
Sure. That absolutely would be sufficient, especially when you have evidence that is not present here in this case, such as slurred speech, maybe stumbling over. There's no field sobriety tests here. There is no slurred speech. There's no
Well, there's a reason there was no field sobriety test.
Well, absolutely. It was an extreme medical emergency. But the fact remains that is a wide void in this case of any evidence that would normally be relied upon not as a DUI as a whole, or an OVI in a whole, but specifically as it relates to a conviction under A1A. Because with the per se offense having the acquittal, there's also the additional circumstances that while that issue is not under appeal, the trial court relied on a lack of a chain of custody. So while, again, that is not under appeal here, I think that brings into question even the validity of this number of .183.
So that's not something you can argue right now.
Well, I think that if...
I mean, that's been waived.
Correct. That I'm just saying if the state is relying on the validity of the .183 and stating that the statements of the trial court stating that there's no question that there was alcohol here, I think there still is a question given the other statements given by the trial court as it relates to the blood alcohol content that's currently before the court in this appeal. Now, I would also like to point out not just the Turner case that was addressed there, where in that case, the Turner case turned on the caused by drugs of abuse. There was already a finding of impairment in the Turner case. Here, we are distinguished from the Turner case, while it's still good law and directly on point as to the caused by alcohol prong of the argument here. We also contend that there is no evidence of impairment as there was in the Turner case. So I think it serves both those purposes well before this court. Additionally, I would like to bring to the attention of this court State v. Grizovic, if I'm pronouncing that correctly, Ohio site 2008, Ohio 3162. That was out of this first district, this court. In the 16th paragraph, the court mentions that similar, there is a expert testimony was necessary to explain how a blood alcohol level over, in that case, 0.1, impaired the defendant's ability to drive. I think that's the exact same issue before the court here today.
Great.
Thank you.
Thank you. Mr. Donovan?
Your Honor, I'll start with the, good morning.
Good morning.
The final point raised by counsel in citing case Grizovic. I'm not familiar with this case. It wasn't cited in the briefs. It wasn't cited in my brief. So I don't have a response as to that. I don't believe that it's appropriate for it to be brought up for the first time on appeal or on oral argument. In terms of the chain of custody, the trial court didn't find that there was a complete lack of chain of custody. They kind of hemmed and hawed this speculation that there's somebody else who might have, and we don't. What the trial court then did was, I'm not going to accept it for a per se violation. There needs to be an exact number. But as Judge Bach pointed out, the court said there's obviously, clearly, undoubtedly alcohol at play in here. And then to factor into the other things, there are other indicia of impairment. This court has ruled, and I'm fairly confident I cited it in my case, that the odor of alcohol plus being at fault in a single car accident is probable cause to arrest for OVI. I know that we're dealing with a different standard, but in those line of cases, being at fault in a single vehicle accident can be considered an indicia of impairment. We have that here.
But you would agree that simply if there was only reckless driving and there's an accident, and if you took the test out of the equation, that would not be enough to establish drinking, even, I mean, the impairment under the statute, even if you're engaged in conduct similar to what you would if you were under the influence. Does that make sense?
I'm not fond of hypotheticals, however,
Right.
You're the judge, so
We get to ask them.
I'll address it. If we have no other indicia of any kind of impairment and we're reading it completely in a vacuum and everything like that, yes, I would say that there are certainly plenty of reasons for being at fault in a single car accident. Lots of them do not involve alcohol. Right. However, and if that's all we had, if that was the only thing that we had, it would certainly make my case a lot harder to establish. We have the location of the offense being outside of Goodfellas. We have that it's in the evening. We have that Mr. Sandcorb was outside obnoxiously revving his engine, the motorcycle equivalent of a, hey, y'all watch this, and then takes off and goes the wrong way through a roundabout. These show an error in judgment, once again, an indicia that can be inferred as an indicia of impairment. It doesn't mean that it absolutely has to be, that it's irrefutable that it is. I don't believe that there are really any things. There's always some sort of, well, the reason for his bloodshot, watery eyes is hay fever. There's always some possible innocent explanation. However, when coupled with the clear presence of alcohol consumption at that time and the erratic behavior, the poor decision-making, the being at fault in that single car accident, these things coupled together to provide the court with an adequate basis for finding. And it's not, as this court is well aware, it's not whether we would agree with that, it's whether the court's decision was a reasonable interpretation of those facts. And we believe that on the facts before the court, it was. In terms of a connection between impairment and the high tier, and that there needs to be expert testimony. The legislature has determined that over .08, impairment is no longer relevant to it because anybody who is over .08, whether there are visible signs of impairment or not, they are impaired by the influence of alcohol, if that is the case. Here we have more than twice that. And while the court doesn't have, the trial court, did not have the specific number, elected not to go forward with a specific number for the high tier, it can certainly say that this quantity, which was significant, provided impairment into that. And so I would disagree with the fact that there needs to be expert testimony. The legislature has said if you're over .08, certainly if you're over .17, that you're impaired, and there doesn't need to be visible signs of impairment to prove that. Because we don't have that specific number, there needed to be that additional indicia of impairment, hence erratic behavior, the setting, where he is, the time of day, and his actions in driving.
Was there any witness that said that he walked out of Goodfellas or whatever the bar was?
I don't believe that there's any testimony as to that. I believe that the first witness, the woman whose name escapes me at the moment, was sitting on the patio at Goodfellas, and that he was out front of there obnoxiously revving the engine of his motorcycle was her testimony. I would have liked to have the answer to that question as well, but it was not asked. And I don't believe that there is testimony as to that, sir.
Okay.
And do you consider his action of driving over the median to be part of the impairment?
Absolutely, yes, Your Honor. I believe that goes towards that is something that can be an indicia of impairment, the decision to enter into that roundabout, going in the wrong direction, and to, I guess it would be this direction, going into a roundabout. That decision-making process in electing to do that, I was going to say high speed, but I don't believe that there was testimony that it was a high rate of speed. But then the subsequent accident, inability to keep the bike on the road, and that subsequent accident also goes to his inability to comport his actions with the law, which was, in our opinion, indicia of impairment. If there are no further questions, Your Honors.
Thank you. All right, Mr. Duncan, you have 5 minutes for rebuttal.
Thank you, Your Honors. As to some of the points that were just brought up by the state as it relates to the relevance of impairment being implied above a .08, that is true, but misguided for purposes of this appeal because the conviction, again, was under an A1A section, not the A1F section, the per se offense. So the state absolutely does have to show impairment, not just a mere number. And again, I think the Turner case clearly states that the state has to do more than just prove impairment in that vacuum. That number is not enough. The theory and the evidence required is different under an A1F prosecution as it is under an A1A prosecution. And finally, in that Turner case, it's concluded that because the state failed to prove a nexus between, in that case, Mr. Turner's impaired condition and a drug of abuse, that was cause for the win on the appeal at that point there. Finally, I would just submit to the court that this is, again, not a per se offense. It is operating a vehicle under the influence. There has to be testimony about what that would look like, and there's a complete lack of facts here providing that. And I encourage the court to not be distracted by the number, which is not relevant in the same way as it would be in a per se offense here. Thank you.
Thank you. Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision and hope you both have a great day.